Good afternoon, everyone. We're just giving folks a chance to come on in. Good afternoon. All right. So we're going to go ahead and get started. Hello and welcome, everyone. My name is Shakima Appleton. I am the Vice President of Webinar Programming for Philly SHRM. We want to thank you for joining today's session, Post-Election Forecast and Update. During today's presentation, if you have any questions, please feel free to send them via the chat function on your screen, and we will read them aloud at the end of the webcast. We encourage you to choose speaker view for the presentation to allow you the best focus on the speaker. As a reminder, everyone is currently muted to ensure the best event experience with no distractions. We also ask that everyone make sure that their Zoom display name shows their full name. By labeling your display name to be your full name, we are able to ensure that you receive your post-event survey so that you receive your HRCI and SHRM credits for attending today's event. To rename your display on Zoom, please go to the list of participants at the top of your Zoom window, then hover over your name and click on the rename button. Type in your full name and click OK. If you're having any difficulty, please direct message the Philly SHRM participant on the Zoom meeting. If you have not done so already, please follow us on Twitter, Instagram, LinkedIn, and Facebook for the latest updates about this workshop session, as well as everything happening with Philly SHRM. And don't forget to check out our upcoming events, including the 2025 Philly SHRM Symposium with keynote speaker Charlene Lee. Join us for this elevated experience, including a new venue, updated menu, more recertification credits, and complimentary valet parking. Registration is now open. To take advantage of the early bird pricing and to register for any of the other Philly SHRM events, visit www.phillyshrm.org. If you're not already a member of Philly SHRM, remember that members receive reduced or free event registration fees, big discounts on Philly SHRM Symposium, personal connections to the local HR and business community, our members-only resource area, including the membership directory, access to top leaders in our region, and a chance to make a difference in our community, and the extensive resources of SHRM National. We want to remind you that you're eligible to receive one HR Business CI credit and one SHRM Professional Development credit for attending today's webcast. You will receive a follow-up email after this webcast with a survey link. The survey must be completed for you to receive the certificate for your credits. Once the survey has been completed, the credit forms will be emailed to you within 1 week. Today's webinar will feature Leanne Lane Coyle, Assistant Attorney with Fisher Phillips. So Leanne, welcome back and thank you for joining us today.
Thank you so much, Shakima. I'm very happy to be with Philly SHRM again. Let me go ahead and share my screen so we can get started on our program. Okay. So today's webinar is intended to give you a legal forecast and what we can expect coming out of the incoming Trump administration. So I had the great fortune of being with Philly SHRM a couple weeks ago to arm you with best practices for navigating election season in the workplace. Now that the election is, I will say, thankfully over, as I'm sure many of you share this sentiment, it's time for us to dive in as to what we can expect with the new Trump administration, regulatory changes we're anticipating, as well as just general Trump agenda items that should be on your radar as we head into Trump administration part 2. And we are fortunate that we have some baseline for what we can expect because of Trump's administration back in the 2016 to 2020 timeframe. So we're also using some of those insights to guide what we can expect and what we're predicting. So Before we dive in, Shakima, thanks for the introduction. Just to give you folks a little bit more about my background, my name is Leanne Lane Coyle. I'm a senior associate with the law firm Fisher Phillips. We are an international law firm that focuses exclusively on labor and employment matters for management. So we are a go to partner for human resources management in dealing with any type of workplace issue that crops up. And part of the benefit of being a firm that focuses exclusively on labor and employment matters is we really have some great insight into many of the nuances that these types of issues present. And so I want to give you some of our inside baseball in this presentation. I'm also really excited today to offer something to the membership for those participating today. This QR code will send you to a link, and all you need to do is fill out your name and contact information, and you will be entered for an opportunity to win a $100 Amazon gift card. And I am actually going to be drawing the name at the end of today's webinar. So if you're anything like me and live on Amazon and get absolutely everything you need delivered to your door, use this QR link, sign up, have the opportunity to get the gift card, and we'll draw that name at the end. So I'll give folks one more minute to scan that, and then we'll get started. Okay. Um, so One other quick housekeeping item. I wouldn't be an attorney if I didn't give you a disclaimer at the beginning that this presentation is not intended to be legal advice. I hope to have some time to answer Q&As at the end of this webinar. If I do so, I can't provide legal advice, but if you have specific questions, I'm happy to always connect, and we can take that offline and find an opportunity to talk. Okay, so I have a bit of an ambitious agenda for us today to cover. So here's the roadmap and things that we're going to touch on. So we're going to talk about, honestly, top of mind right now is some wage and hour rollbacks that just actually recently happened and how we see those shaking out with the next Trump incoming administration. I'm also going to talk about some changes that we anticipate in terms of EEOC enforcement, and then we're going to talk about a return to a bit of a more level labor playing field with what we're seeing in terms of incoming Trump administration. And the last 2 points are going to be brief topic items, but we are going to touch on some anticipated relaxed workplace safety standards and a little bit of uncertainty with the state of non-compete ban that we don't have too much certainty on, but aspects that I want you to be mindful of if your organization does implement and utilize non-competes. So let's dive right into wage and hour rollbacks. The biggest one being just last Friday, a Texas federal court set aside a Biden administration final rule that would increase, and in fact already did increase, the salary threshold for white collar exemptions to the overtime requirement. So that was a mouthful. Let's break that down a bit. So the expectation and default is that employees are eligible for overtime unless they meet certain exemptions. Some of those exemptions are known as the white collar exemptions. We're talking the professional, executive, administrative exemption. In order to qualify for those types of exemptions, an employee has to meet both the duties test, which is a specific list of factors of certain job responsibilities that they have, as well as a salary threshold. So the employee must also earn a certain amount per year in order to qualify for the exemption. So what did the Biden administration do? Essentially, they sought to expand overtime coverage to millions of Americans by increasing these salary thresholds for an employee to be eligible for that exemption. So the final rule was adopted in April, and the first salary threshold increase happened as of July 1, and that increased the salary threshold to 44,000. We were expected to have another increase and jump pretty significantly to 59,000 as of January 1. But just last Friday, a judge in a federal district in Texas set aside the rule and said that the Department of Labor, specifically the Wage and Hour Division, exceeded its statutory rulemaking authority by establishing these salary increase requirements. So, what does that mean for you in a practical way? Well, basically, the salary threshold for the white collar exemptions has reverted back to 35,000. Today, that is the law. Provided that an employee meets the duties test for those white collar exemptions, they just need to earn 35,000 per year to qualify. So, what does this all mean, and what are we expecting to see coming with the Trump administration after the inauguration in January? Well, so the Texas District Court decision can be appealed by the Department of Labor and go up to the Fifth Circuit Court of Appeals. For those of you that don't know, the Fifth Circuit Court of Appeals is an extremely conservative bench, and it is where we are seeing a lot of challenges to regulatory enforcement and some of these more bureaucratic initiatives that happen, for example, during the Biden administration. But nevertheless, the department can still appeal the district court ruling, but we do think it's unlikely that the appeal is actually going to be decided before Trump takes office in January, meaning that we expect the 35,000 threshold is going to remain in place until Trump comes into office. And then once Trump takes office in January, um, we don't think that the administration is going to push for and try to challenge further the rule being set aside by the Texas District Court. So, back in 2017, when Trump took office, he actually rolled back an Obama era rule pretty immediately that would have expanded overtime protections for many employees. So, if Trump administration 2 tracks what it did in Trump administration 1, we don't think that there's going to be continued efforts to enforce this rule coming out of the Biden administration. And in fact, our prediction is that the Trump administration is just going to scrap the rule in its entirety, meaning that 35,000 will continue to remain the floor and threshold for the white collar exemptions. So, what does this mean practically for your organization, and what should you keep in mind while we wait to see how these issues shake out? So, technically speaking, your organization can roll back any salary threshold increases that were made as of July 1, and or if your organization preemptively increased salary threshold in anticipation of the 59,000 increase slated for January 1, technically right now, legally the company can roll back and go back to the $35,000 threshold. However, we're suggesting waiting to roll back for a couple reasons. First, and I think most importantly, is you're going to have to really take a hard look at what a rollback would do to employee morale. I mean, one of the issues that my clients dealt with in the first place was dealing with deciding whether to actually increase the threshold or convert employees to hourly based, which again implicated some employee morale considerations. If we are to then repivot and roll back some increases that maybe happened, I think the likelihood of it impacting your workforce is significant. I also recommend just waiting on any rollbacks to see how additional challenges to the Texas District Court decision might shake out. So while we're predicting that the Trump administration won't continue to challenge that court decision, it really remains to be seen. I mean, I unfortunately don't have a crystal ball. We have some insight based on what Trump did previously, but I think it behooves organizations to just see what type of challenge will continue or be abandoned before you actually roll back. Now, obviously, that means if you didn't preemptively increase to the 59, you don't need to do so at this point. An important aspect, I'm going to skip to the third check mark here. An important aspect as you're evaluating whether to roll back, though, is it's really critical to check any state law requirements because if you work for a multi state employer, there might be some state law requirements for advanced notice of wage changes. So you're going to want to make sure that you comply with any state or local requirements regarding notification to employees concerning any wage changes. Pennsylvania doesn't have those types of requirements, but there are other states that do. So it's important to just check on those before you implement any type of salary change. And lastly, one thing that we really do think is going to happen as this shifting regulatory landscape with the overtime threshold is sort of panning out, is we do think that there's going to be increased scrutiny from plaintiffs' attorneys about employer pay practices, particularly as employers might roll back salary increases or shift classification of exempt or non exempt. I think that we can expect a good amount of lawsuits to be filed, really trying to challenge employer decisions, candidly, just capitalizing on a lot of uncertainty that's at play at this stage. So I say that not to scare you, but just to make sure that you're mindful that we could see a lot more scrutiny by way of litigation as these issues really play out. Another aspect in the wage and hour realm that we think is likely to change under the Trump administration is the possibility of more folks being classified as independent contractors versus employees. So, in Trump administration number one, the Department of Labor did finalize a rule that made it significantly easier for businesses to classify folks as independent contractors versus employees. However, when Biden took office, he scrapped that rule pretty immediately and then thereafter implemented a final rule from the department that adopted what's called the economic realities test. So there were and there have been a couple different tests out there that both agencies and courts use to evaluate whether an individual qualifies as an independent contractor versus an employee. Trump's rule tightened the factors considered and took it down to two, which enabled agencies and courts to more likely be able to find independent contractor status. The Biden economic realities test is much more multi-factored. I think there's 6 factors that are taken into play. And because of the multi-factored nature of the economic realities test, it is much more difficult to meet that independent contractor bar. The standard is much higher, so it is much more difficult to classify folks as independent contractors without potential exposure for a misclassification claim. Coupled with this also is the Biden era National Labor Relations Board issued a decision in 2003, which actually predated the Department of Labor Biden era rule on the economic realities test. This came down in 2003, but the NLRB similarly adopted a heightened standard for classifying individuals as independent contractor or employee for purposes of labor relations and National Labor Relations Act purposes. So These two departments joined together to make this issue much more difficult. But what we expect from the Trump administration is we think that the Trump Department of Labor and the Trump NLRB is likely to reverse course once again and restore the Trump 1 era tests that made it much more easy for businesses to classify folks as independent contractors. So, what does that mean for your organization? Well, I wouldn't immediately run off and start reclassifying folks as independent contractors just yet. It is going to take some time for a Trump Department of Labor and the NLRB to go through the regulatory framework to change the economic realities test. So, this isn't the pendulum has automatically swung and now it's free reign to reclassify folks. But be aware of the fact that we will likely see some rulemaking changes, and this might impact the way that you're evaluating classification issues as you look at, some folks that maybe perhaps you think should be an independent contractor, but it was just really difficult in the Biden era rule to meet that threshold. You might have an opportunity to re examine that as the Trump DOL and NLRB possibly pivots on the Biden era standard. So, shifting away from wage and hour changes that we see coming down the pike, and some of which have already, I want to talk about what we anticipate in terms of some changes to the EEOC and its regulatory enforcement agenda. So, under the Biden administration, we saw a really proactive EEOC and really aggressive enforcement agenda, particularly in three main areas that we think the Trump administration is going to all but abandon, if not, and I'll talk a bit about this more, if not perhaps completely reverse course on. So, we think that the Trump administration EEOC is going to place less emphasis on enforcing DEI initiatives that the EEOC was focused on during the Biden administration. Pardon me, folks. I'm a little under the weather, so don't mind my frogginess. I'm trying to power through. But we also expect that there is going to be a shift away from the EEOC's focus on addressing specifically LGBTQ discrimination in the workplace. That was a really high priority enforcement initiative under the Biden era. And we think the EEOC agency is sure to move away from that particular focus. And there's one aspect of that that I want to talk about a little bit more too. Um, we also think that the EEOC is not likely to remain aggressive on enforcement initiatives with respect to pregnancy discrimination. And you'll recall that back in 2023, the Pregnant Workers Fairness Act was adopted into law, which provides for reasonable accommodations for pregnant workers. That law will remain good law, but we don't think the EEOC is going to be as focused on enforcing and bringing about lawsuits against employers for Pregnant Workers Fairness Act violations. We recently saw an uptick in EEOC enforcement efforts in that respect, but I think that we're not likely to see much momentum on that as we head into the Trump administration. So, what to expect? I want to talk about a little bit, and this might be getting in the weeds, but I think that it's really helpful for all of us HR folks to keep in mind while we're looking to how the regulatory landscape might change and how this might impact what type of trends we see with respect to discrimination in the workplace. So, the EEOC has a general counsel that is really at the helm of much of these enforcement initiatives. We expect that pretty immediately after Trump assumes office, he is going to he's going to scrap the existing GC of the EEOC and insert a new GC who will carry out a enforcement agenda that is going to align with the Trump administration's goals and priorities. Besides the general counsel, the EEOC is comprised of several commissioners who serve a certain year term with the EEOC, and these are staggered terms to allow for changes in administration between Democrats and Republicans to the idea creates some balance between the two ends of the political spectrum with the commission, but in reality, at least right now, the commission board members sway heavily blue. So, what does this look like with the Trump administration coming in? Well, there is actually currently a vacancy on the commission that I expect Trump will fill pretty immediately. And there's going to be another one coming in 2025, although that current commissioner was actually, in fact, a Trump appointee. So I wouldn't be surprised, candidly, if Trump renews her term on the commission. Um, the Democrats who are currently on the commission, their terms will expire 2026, 2027, and 2028, respectively. So all of those fall within the next Trump administration. So it's possible that we might see significant momentum with instituting Republican appointees to the commission that might really impact the regulatory enforcement agenda of this agency. And I'm going to put a pin in one comment that I'm going to have about that in just a moment. Um, Also, it's important to keep in mind that the EEOC has a general counsel, but it is the Department of Justice that actually has to carry out these enforcement initiatives when we're talking about actually filing lawsuits against companies and against employers to bring Title VII violations in court. So there is Trump has announced who he would like to appoint as chief of the Department of Justice, Matt Gaetz, a representative from Florida. And the DOJ under Gaetz, assuming that he is confirmed by the Senate, might have a very different approach on bringing or continuing to pursue claims coming out of the EEOC. So honestly, my prediction in this respect is the change to the Department of Justice is likely to hamper some of the, specifically the EEOC under the Biden administration, placed a heavy emphasis on harassment issues in the workplace. For those that don't know, the EEOC issued new guidance on harassment in the workplace during the Biden administration. I would absolutely take a look at that if you haven't. But I think that the DOJ under Gaetz is not likely to really build momentum on pursuing and trying to address harassment in the workplace by filing lawsuits against employers. Um, One of the things that became a hot button topic during the election, particularly, implicates issues of gender discrimination at work. So, one of the focuses of the conservative and Republican ticket was transgender issues, particularly in sports, in schools, but also, we see these types of issues crop up in the workplace. Um, it is important for us to keep in mind that notwithstanding the platform that Republicans embraced on this topic during the campaign, discrimination based on gender, which includes gender identity and transgender status, is illegal. That was confirmed by the Supreme Court, and we don't anticipate that that will change in any respect. But I think that the commission under Trump, particularly as Trump is maybe able to appoint more Republican and conservative folks to the commission, I think that there's going to be some rollback on some positions that the EEOC has taken, particularly with respect to the harassment guidance. So, one of the aspects of the EEOC harassment guidance dealt with specifically um, gender identity issues when it comes to bathrooms in the workplace. The EEOC in its enforcement guidance took the position that an employer prohibiting an employee from using a restroom that aligns with their gender identity runs afoul of Title VII. The current Republican commissioner on the EEOC, a woman by the name of Andrea Lucas, she has come out very publicly against the EEOC's position in this respect. And I wouldn't be surprised if she was able to make some inroads on this issue if more conservative picks from Trump are to join the commission. Ms. Lucas's position is that Title VII still requires that women in the workplace are protected, and her position is that allowing employees to use bathrooms that align with their gender identity, pardon me, poses a safety risk for women in the workplace. So, regardless of how you come out on this issue, I just think it's important to note that there's a possibility that we might see the EEOC vacillate on its position in this respect. Importantly, the Supreme Court decision that made clear that transgender status is protected under Title VII, that Supreme Court decision specifically caveated by saying that the decision was not addressing issues such as or pardon me, not workplace, but restrooms. And so there is a little bit uncertainty in the law in this specific and nuanced respect. So something to just be on the lookout as we see these changes coming in with the new administration. Okay, so pivoting off of discrimination in the workplace and Title VII issues is the impact that the Trump administration is going to have on labor relations, particularly with respect to the National Labor Relations Board. So I think this topic is really interesting because, you know, it was surprising to see the Trump administration and Trump and particularly JD Vance, the VP, incoming vice president, really embrace the unionized workforce of America. And the Republicans managed to really connect with union workers during the campaign and really seem to align themselves with pro-labor initiatives. But we know from Trump administration one that Trump's prior regulatory agenda was very business friendly and really reluctant to adopt pro-labor and pro-union initiatives. So it really is going to be interesting to see how if Trump's position in this respect might pivot in light of what happened on the campaign trail, or whether he will return to his sort of view and regulatory focus or lack thereof on labor issues in Trump administration too. But in terms of our predictions, in terms of my predictions, I think that there's going to be significant rollback on NLRB Biden era overreach. I mean, candidly, the National Labor Relations Board General Counsel, who Biden selected, took an extremely aggressive approach about what could be dealt with by the National Labor Relations Board. And I think it was a significant overreach, even in light of the broad authority that the National Labor Relations Board has. So I think we're going to see significant rollback in that respect. And I'll talk about some more specifics on the next slide. I also think that there's a question of the balance of the NLRB generally. We have a Democratic heavy board, and board members serve for 5-year terms on the NLRB. So we'll talk about what that looks like in terms of who is going to be up for, or what seats are going to become available soon. But I think the balance of the board is really in question at this point. So hanging in the balance at this stage, and what we are looking out for and what we are thinking might change with Trump administration and Trump NLRB. So as I said, Biden's NLRB was extremely aggressive. There were several decisions that came out that really changed a lot of the landscape for employers. For example, the CEMEX decision that changed entirely the framework by which employers have to recognize a bargaining effort by a union. It made it so much easier for unions to make inroads with unionizing a workforce, and that decision could be at threat. I mean, we could see a Trump NLRB roll back or overturn that decision in its entirety. We also saw the Stericycle decision come down during the Trump administration, or I'm sorry, during the Biden administration and by Biden's board. So that decision impacted the types of policies that employers can enforce, particularly with respect to handbooks. So we might see a rollback or an overturn of that Stericycle decision in its entirety. Very recently, actually, just last week, the NLRB issued a decision that banned captive audience meetings, which is an opportunity for an employer to require its employees to attend a meeting to talk about what type of impact could happen if they were to adopt a union in the workforce. Um, that is now impermissible under the NLRB's recent decision. So we'll see if Trump's board tries to do something about that decision. And there's also, I'm calling it the Black Lives Matter ruling. So there was a decision that came out of Biden's NLRB that significantly expanded employees' ability to express political and social issues in the workplace, particularly with respect to insignias on uniforms. In this case, it was an employee wearing a Black Lives Matter pin. And even though that's not, particularly, it doesn't seem union related, the board issued a decision that expanded employees' ability to express themselves in that type of manner in the workplace. So a lot hangs in the balance. It remains to be seen what will happen with these decisions, but it's something to keep in mind. I want to talk to you, as we discussed, the composition of the EEOC Commission. The National Labor Relations Board is a board comprised of individuals that are selected by the president. But the NLRB operates a little bit differently because there's basically this protection for board members who are appointed that they essentially can't be removed except for cause, which is a significant dereliction of duties. There is a growing movement of businesses and sort of, thought leaders as to whether this limitation on the president's ability to select board members is even constitutional. In fact, there are actually challenges to the constitutionality of the National Labor Relations Board itself. Um, Very recently, we see momentum from SpaceX, Elon Musk's company, which, for those of you who don't know, Elon Musk is actually going to play a role in Trump's administration under a newly deformed Department of Government Efficiency. So SpaceX is challenging the constitutionality of the National Labor Relations Board in its entirety. They're a company that came under significant scrutiny by the National Labor Relations Board and faced a number of unfair labor practices charges. And also another company joining SpaceX in this initiative is Amazon. And as you can imagine, SpaceX and Amazon, they have incredible resources, an army of attorneys, and they are undertaking a movement to see if they can challenge the constitutionality of the board itself, which would fundamentally change this regulatory landscape because you wouldn't have decisions like Stericycle, like CEMEX. It would basically cut off at the knees the National Labor Relations Act and the ability to enforce or create regulatory requirements under that statute. Um, Circling back to, so the current chair of the National Labor Relations Board is a Democrat pick, is a Biden pick, but her term expires in December of this year. And so it's an open question mark. Maybe the Biden administration is going to try to push for appointment of a new chair before the inauguration. I don't know if they're going to be able to get that through, and particularly get it through the Senate in time before January 20th, um, perhaps. But if Biden isn't able to do that, which honestly, I think the likelihood of that is pretty minimal, we're going to see a Republican appointed chair. And then two Democrats are going to be up for selection during up for new appointment during the Trump administration in 2026 and 2028. So it's supposed to be a 5-member board, one of the members being the chair. Um, it has actually only been 4 members. There's one Republican. The other Republican chair has remained vacant. So I expect that Trump will try to fill that chair pretty quickly, and also appoint a Republican chairperson, which will swing the balance of the board to Republican majority. And also, one thing that I'll add that some of the thought leaders in my firm are wondering might happen is the possibility of Trump firing the board in its entirety. It's rumblings that are happening in Washington about whether Trump might try to come in and just wipe a clean slate and institute only either Republican appointees, or to sort of fall in line with the fact that there need to be some Dem chairs, some Dems who might fall more in the middle or might be more willing to embrace some of the Trump agenda. So that's kind of an open question mark. I think it's something interesting, if you're interested in it, to be on the lookout for. But my prediction generally, and this is less of a prediction, but more of just I think things are going to get really messy with respect to the National Labor Relations Board. I think businesses are rightfully upset and frustrated with the aggressive approach that the board took during the Biden administration, and the enforcement efforts under Biden were so extreme that I think the pendulum might swing that much harder in the opposite direction. So I think because of that, there's a greater likelihood of things just becoming messy. And I think things are going to change a lot. And as an employment and labor attorney, I'm sort of already expecting my head to be on a bit of a swivel as these things shake out. So it's important for you to really stay in tune with how these issues might just, change and change back. And, it's going to be breaking news probably on a routine basis. So pivoting now off of labor relations is some anticipated changes to some workplace safety standards that were adopted and expected to be implemented from the Biden administration. And the first one actually is related to the labor relations aspect that we just discussed. So one thing that OSHA did during Biden's administration is adopt a new rule which permits a union representative and or any representative on behalf of the employees to be part of safety walkarounds conducted by the agency. That is an incredible change to the status quo. And as management attorney, all of us at Fisher Phillips were just a bit aghast at the fact that this even managed to get to a final rule. But I think the Trump administration is going to completely scrap this. And, honestly, for good reason. During these walkarounds, I don't think that it serves anyone's benefit to have a union representative who is likely to try to point out various issues. I think that there's a time and a place, particularly by the OSHA investigator, to address issues without the added input from a union representative who might not be attuned to workplace safety regulations, might not have an understanding of what is, what is appropriate, what is not. So we expect a rollback and scrap to this rule in its entirety. The Trump administration, number one, also significantly cut the budget for the number of OSHA investigators, and we think that this is going to end up being the same. I mean, I mentioned the new Department of Government Efficiency. Trump is absolutely focused on cutting government spending and significant deregulation from a bureaucratic standpoint. So I think that we are going to see a significant cut to the number of investigators at OSHA agency, which I think is going to impact the number of OSHA inspections. So I just wanted to add here, my firm has a really awesome tool. It's a heat map for OSHA inspections on a national basis, and it shows trends that are happening, which I think is an invaluable tool for any workplace to get a sense of, where are we seeing heightened enforcement efforts? If you are sort of on and in the area on the heat map that is pinging, you should be a little bit more attuned to the possibility that OSHA enforcement is sort of possibly heading your way. However, I will add, so if you follow this OSHA inspection tracker, I think we can anticipate in the coming initial months of the Trump administration and over the 4 years that this heat map is going to significantly cool off. So if you're interested in tracking these trends, this QR code will take you to the link that will show you where we're seeing enforcement activity. And lastly, here, I'm hoping to leave a couple minutes for questions, and I'm going to draw a name for our gift card. So, non-compete uncertainty. Let me give you the quick rundown of how we got to where we are. So, if your organization utilizes non-compete agreements, you're likely already in tune with this issue. But basically, the FTC under the Biden administration adopted a rule and proposed a complete ban on non-competes. Now, there was significant backlash from the business community, and in connection to that, significant legal changes to this proposed ban. So there were a couple different court cases challenging the FTC's authority to implement this kind of rule in the first place. One of those challenges was down in Texas, where, as I mentioned, there is significant activity to regulatory challenges in this conservative state. So, a Texas district court over the summer in August set aside the rule. It was actually a couple weeks or months before the judge set aside the rule with respect to Texas state employees, but then the judge issued a second decision in August, basically saying on a nationwide scale that the FTC lacked the authority to implement this rule. And a critical part of this is some of you may know that the Supreme Court issued a decision that basically did away with Chevron deference. So what that means, under existing Supreme Court decisional law, there was a standard called Chevron deference, which was basically when a court was reviewing any agency enforcement or rulemaking, it would defer to the agency in promulgating those rules. The Supreme Court recently struck down that Chevron deference, which means that any and all agency rulemaking is subject to judicial scrutiny. And that means that we might see a lot more challenge. We already have seen a lot more challenge to some of these regulatory initiatives from agencies such as the FTC. So, Texas set aside the rule. It has been appealed. The FTC has appealed the Texas decision. That remains pending as of the present. But what's interesting and what I want to put on your radar is, we expect that Trump is going to appoint the chair to the FTC, who will align with Trump's stance on this issue, which is pro business and against a non compete ban. But something that's really interesting is we talked about Trump's pick for the DOJ, Matt Gaetz. Well, Matt Gaetz is a bit of an outlier in his amongst his Republican colleagues because Gates has actually come out in support of the FTC ban. He actually has an interesting perspective on antitrust and anti-competition uh, initiatives. And he actually, in the Texas case, he filed an amicus brief, which is basically him voicing his support to the Texas court saying, hey, we should allow the non compete ban to take effect. So, one thing that we are watching and monitoring is if Gates is approved by the Senate, will he try to influence the ongoing rulemaking efforts? And will he possibly pick up the Department of Justice's continuing appeal and challenges to the Texas court's decision? Or will Trump manage to appoint an FTC chair that is going to basically abandon the appeal, let the ban die, and return to the status quo, which is, generally they're permitted subject to state law. Make sure you're always thinking about states have various requirements. Some states have bans. So, of course, subject to state law, but something that remains to be seen as we are, heading into the new administration. And my prediction in that respect, it's anyone's guess, honestly. So, stay tuned. And on that note, um, I've talked about a lot of things that are going to possibly be shifting, but the reality is that we just don't know until these things actually shake out and until Trump actually takes office in January. So, the best thing that your organization can do at this point is to stay ahead of the curve and stay on the latest changes. My firm makes that really easy. We have an incredible content team that exclusively tracks these issues. And I have included here a QR code for our insights. So you can subscribe to the insights that we push out, and you can pick specific topics that you want to be alerted about. You can also pick specific states. So you're not inundated with everything. It's tailored to what you need to know. And it's a free resource. It's a free to subscribe. So it's an incredible resource. I really encourage you to take advantage of it, so you can know what's coming down. So I think that I do have a couple minutes for questions. Shakima, if you saw any come into the chat while I take a look at our list of those who registered for a gift card and pull the winner here. So, Shakima, any questions from anyone?
No questions came through the chat, but we'll leave a moment for folks to add questions.
Okay, wonderful. All right. So I am pulling up our um, registration list, and let me click the button for the randomizer. And okay, hold on. Oh, all right. It looks like Kim Hugel. I'm sorry if I'm mispronouncing your name.
That's correct.
Oh, okay, Kim Hugel, you are the proud winner of a $100 Amazon gift card. We have your email. I will reach out to you so we can arrange for that to be sent to you. Thanks everyone who submitted. Hopefully, if I have another opportunity to come back with Philly Sherm, I hope to have another raffle surprise for you folks. But knowing that there's no questions, if you have any questions on the side, I am happy to connect. Um, one thing that I didn't include here is my email address. So I'm going to drop that in the chat really quick. If anyone is interested in ever reaching out to me, has questions or concerns about some of the things that we discussed, Again, thanks everyone at Philly Sherm for your time. I love connecting with you all. And I hope everyone stays sane as we see all of the changes that we can anticipate with a new administration at the helm. Thanks again.
Thank you so much. And thank you for each of you for joining us today for this webcast. As a reminder, please look for the follow-up email with the link to the survey and be sure to complete the survey in order to receive your HRCI and SHRM credits. On behalf of Philly SHRM, thanks again and enjoy your afternoon.
Thanks, everyone.